case briefs, and so much more. LSData's got what you're looking for.
In the 2006 case, Dewbrew v. Dewbrew, the Court of Appeals of Indiana addressed the importance of protecting children's interests in property settlement agreements during divorce. Tina and Herbert, who married in 1990 and had 2 daughters, started discussing divorce in 2003. Herbert filed a petition for dissolution in 2004, and an attorney drafted a divorce agreement discussing the distribution of marital assets, such as Herbert's businesses. However, the agreement did not include child support, as the couple had agreed to omit it. Tina refused to sign the agreement, considering it unfair, and later filed a motion to correct error or set aside the property settlement agreement for not dividing significant assets like the marital residence and Herbert's businesses. The court found that Herbert had mingled child support and spousal maintenance, and the agreement did not adequately provide for the children's welfare. Tina appealed the court's decision, raising 2 issues: whether the agreement should be set aside for excluding child support, and whether it was manifestly inequitable. The Court of Appeals ruled that the property settlement agreement between Herbert and Tina was deficient, as it failed to divide significant marital assets, including the marital residence and businesses. Furthermore, the court found that mingling child support and spousal maintenance was unjust. The case was remanded with instructions to recalculate the entire division of property, distinguishing child support from spousal maintenance. The court emphasized that a partial modification of a property settlement agreement might necessitate reconsidering the entire division to prevent an unjust outcome.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.